You are live. You are live. You are live.
Are we ready? Hello.
You are live. Please go on.
Hello. Good morning, everybody. Can we go on?
Yes, you can. You're live.
Good morning, everybody. Please welcome to this session discussing the dispute resolution protocols in the AfCFTA. And I want to thank everyone who has joined for this session, particularly the panelists who are going to go through the topics with us. Because of time, I think we'll just go straight to the business of the day. As we all know, the AfCFTA is domestic to the African continent. And to start the discussion, I'm going to firstly introduce to you the speakers this morning. We have Mr. Adetola Onayemi, we have Diane Okoko, we have Professor Abomadaki, and we have Prince Adetokunbo Bokayo, SN. If you listen to the discussions that went on just before now, you would have heard Professor Lumumba talking about African dispute resolution mechanism. In the context of that, I'm going to invite Mr. Onayemi to discuss with us the overview of the AfCFTA against the background of other international dispute mechanisms like WTO and other protocols like that. Mr. Onayemi, if you are ready, please help us to discuss the topic against this background. Thank you.
Thank you very much for, thank you very much, Leonard SCN, and thank you for the invitation to the entire CIAB team for putting this together. As we fast approach the 1st January 2021 start date for the AfCFTA, it's very great to know that we're having conversations around the AfCFTA dispute settlement mechanism and what that involves for the different member states. This is a topic that I've written very frequently about, and as one of the people who was involved in negotiating the African Continental Free Trade Agreement with the late Ambassador Chiedu Osakwe, it's a great opportunity to be able to talk about this and what it means for us today. So I'll start from the beginning. The AfCFTA is designed as a mechanism or as a framework for all the different African countries to actually start to articulate very clearly how to work together for trade. So the intent of the African Continental Free Trade Agreement is trade. Basically, how can I get more African countries trading amongst themselves? Now, if you follow the AfCFTA at all, one of the things you will know is that the AfCFTA actually relied extremely heavily on the dispute settlement mechanism of the WTO. And the reason is very clear. The reason it's very clear is because for the longest time, the most effective dispute settlement mechanism in the global trading system was actually the WTO dispute settlement mechanism. And in fact, we'll generally call it the crown jewel of the dispute settlement mechanism. And so when we were designing and negotiating the African Continental Free Trade Agreement, one of the things that we relied very heavily on was actually the AfCFTA, the WTO agreement, because it just gave us a great template to understand what to work on. And one of the things we did was to try to improve on that. Now, so in the context of that, I'll set out some of the broad strokes of how the AfCFTA is set out. The AfCFTA mechanism for dispute settlement very quickly sets out what we call the 4 parts to negotiation, or the 4 parts to dispute settlement, right? The first one is what we'll call the panels, right? Okay, let me backtrack a bit. The first one, when the dispute between 2 parties on trade, the first thing you have to notice is that the AfCFTA mechanism contemplates dispute settlements between 2 state parties and not 2 private parties. And that's one of the things that makes it starkly different from the more traditional international arbitration or international commercial litigations, but it sets out a regime for state parties to sort out issues amongst themselves. The second thing you said very clearly is that it says that when 2 parties have a dispute, the first thing you want to do is it says that the parties should actually consult among themselves and resolve the dispute. So the first thing you would see is actually what we'll call consultations. And the idea is very simple. The WTO from which the AfCFTA was set out expects that when there's a dispute, the two parties should be trying to resolve it among themselves as quickly as possible. And so before it takes it out of the rights of the parties to go to a third party, it basically says third parties amongst the two of you try to find a way where you can negotiate and figure out this dispute. So it says consultation. So State A and State B will try to consult between themselves and come up with what we call a mutually assured solution. So the idea is that both of you together will discuss and come up with a solution together. Now, if that does not work, there's something called the second part. The second part is mediation. And the mediation idea is that you are actually leaning more on basically things like the good offices of the Secretary General of the AfCFTA. So the idea is that if the two state parties can't figure out a dispute settlement mechanism among themselves, you can then start to look to a third party like the Secretary General of the AfCFTA to help you resolve that amongst yourself. Now, if that does not work, the third part is what we call panels and arbitral and appellate bodies. Now, and this is actually what's the most popularly used all around the way, even at the WTO. We use WTO as a context. So what happens really at this level? What happens is very simple, is that you actually have a regime where each state party, long before disputes happen, actually will send names of panelists that they want to be put up on this arbitral panel. So each country will send a number of people with their CVs, and they'll be selected and put on that panel. Now, from that broad list, what happens generally is that when a dispute rises and needs to go to an arbitral panel, the parties will get together with the Secretary General to actually select who will dispute and litigate on their cases. And based on that, a person will be selected to actually, a panel will be selected to actually make decisions on that case. Usually it's a panel of 3 persons that will generally be set up. Now, if the parties do not agree with the findings of the panel, they can appeal. And that means that an appellate panel can also be set up within that regime. So the idea is that you still don't agree with the findings of the panel, and you want to set out a system for appeal. Now, if all of that doesn't, and that's the 3 parts. Now, there's a 4th part, and this 4th part is actually called arbitration. Now, but there's something called the fork in the road in the AfCFTA dispute settlement mechanism. And the idea is simple. The idea is that once you select to use one of the parts of dispute settlement, you are not allowed to use any of the other parts. So you've got to pick which of the parts you want to use. You can't just use you can't use all the parts. And why is that important? It's important because you don't want a case where a matter has been litigated between one party and gets litigated between another party. But there are a few exceptions. One of the exceptions, for instance, is that in the cases where your parties submit to an arbitral panel or an appellate body panel, and one of the parties is being difficult, right? It means that to a great extent, you actually can reach out to Secretary General to intervene. That's one. There's another exception is that in cases where you've gone to arbitration, and when you're in arbitration, the party is not cooperating with the arbitrators, you can actually take it back to the arbitral panel. And so one of the things that you find very popularly is that within the AfCFTA regime, which is very much reliant on which is very much built in the same design as the WTO regime, almost the key system, you would say, is actually the arbitral panels, because it's almost the one that everybody reverts back to. That arbitral panel system is what everybody reverts back to. Now, but this raises a number of questions. And one of the questions it raises very quickly is, what exactly is the role of arbitration in the light of the arbitral panel more generally? Now, the first things first I should say also is that if we were to use the WTO as context, what you'll find out is that most parties would actually generally go to the arbitral panels and these appellate bodies rather than arbitration. But there were a number of instances which parties would generally go to arbitration within the AfCFTA, just from preference, from trends we've studied. One of those patterns is cases in which it's about determining the extent, the equivalence rules. And the equivalence rule is simple. The equivalence rule is that if I'm saying that a party offended me or a party breached their obligations, in determining the level to which I can retaliate against them, the equivalence rule says you must retaliate in equivalence with the damage that was done to you. So a number of times when parties dispute on that, they generally take it to arbitration because it's an easier thing for arbitration to resolve. Another example of where parties generally go to arbitration is if after an appellate award has been given in my favor, and a party is saying that that appellate award is too exorbitant or is too excessive, or if I'm claiming that I have complied and the other party says you've not complied, so non-compliance proceedings are generally taken to arbitration panels. Now, another interesting thing to say is that a question that comes up very quickly is, how exactly does this work in the entire framework of African countries, right? And what I mean by that is this: within WTO, one thing we noticed very strongly was that African countries would not litigate, right? Will not take cases to arbitration, will generally avoid arbitration. And so one of the big concerns in designing the AfCFTA regime was, what is the incentive to ensure that African countries actually use the mechanism that are set up? Because you don't want a case where you're setting up a mechanism and nobody's using it. And that's a big concern. So there's a lot of research done on this, a lot of academic research done on this. There is no, one of the reliance people have come up to is that the cost of arbitration is probably one of the pushbacks, and the cost of arbitration panels is one of the pushbacks. Another thing that people have said is that it might also be because African countries are having to deal with even non-African countries. And so maybe that's the hesitance why they're not as prone to litigate. But the truth is that the hope is that now within the smaller AfCFTA that just has 54 African countries, what has to happen is that you either as an African country have to use that mechanism, or you come to a system where the AfCFTA system will not evolve. Because the way the rules are set up, a lot of issues can only be resolved by member states coming to arbitration. And I'll give an example. As of today, there are a number of member states that are still not technically ratified the AfCFTA. The question becomes, if there's a dispute between those members and those that are ratified, how do you resolve it? Another example is, if there's a third-party dispute between how rules of origins is applied, or how a third-party rules is applied, or even legacy obligations, one of the easiest ways to resolve that is to go to the appellate system and have them make a decision on how to resolve the dispute. And so what you're saying is that the AfCFTA dispute settlement, which is very much styled after WTO dispute settlement, is built in that fashion. Now I'm going to try and pivot again a bit to the ECOWAS system and what exists within the ECOWAS system. So the ECOWAS system has a more watered down system where it basically says that if there's a dispute between the parties basically can lay complaints to the ECOWAS Commission, and the ECOWAS Commission can try to resolve issues between the parties. He also talks about how you can go to the head of the ECOWAS Secretariat to help design. And we also know that there's already been set up to an extent the ECOWAS courts. But the truth is, what we've also seen is that the ECOWAS courts have been a lot more vibrant with human rights cases rather than having investment type cases. And so one of the conversations that has come up in recent times, even as we go into the next phase of negotiations, has been, what is the role of actually designing an investment type court? Because the truth is, as of today, the mechanisms that exist within the AfCFTA are still designed for state parties. It's still designed for country and countries. So what exactly is the regime for private sector parties? What exactly is the regime? And so there's been pushback. So member states would strongly, and I can't mention, of course, member states here, but member states strongly believe that you need to ensure that it stays within state-to-state party litigations so that it's vibrant and so that there is a parity and there's no abuse of the process, like what's happened in recent time with investment arbitration. But of course, some members have raised up the issue of saying, if you're going to negotiate investment, which is what is being done now, if you're going to negotiate data privacy, if you're going to negotiate e-commerce, then you have to give private sector parties access to this court, right? But the question becomes, you want to create a bifurcated system of courts where the states can sue the states, and the private sector can sue private sector. And so you're having a bifurcated systems of that sort. That has still not been ironed out. But in a more broad way to set out and just to wrap up my thinking around this, what we currently have is a system that is built almost in the same lines as the WTO, and which is the principal reason why the WTO has become so effective. Because within the international trading regime, states need to know that there's a way to hold people accountable, and there's an accountability regime. In the absence of an accountability regime, what happens is that you create a system where parties are not willing to engage with that system, and so that system does not evolve. And so the reason why the WTO has become, over the last few years, the most effective dispute settlement mechanism in the world is because of its dispute settlement procedures, which has now been brought into the AfCFTA. So as we approach the 1st of January's timelines for AfCFTA trade to start, it's interesting to see how that plays out and how state parties in Africa would engage with it. Thank you.
Thank you. Thank you very much for a very good presentation, Tola. I think that we've had Tola speak about the AfCFTA within the context of the WTO dispute mechanism. One significant thing you would get from his presentation is that the AfCFTA mechanism heavily relied on the WTO dispute settlement mechanism. I think that's quite commendable. The only thing we want to look at now is that in the context of what we are trying to develop, to grow an African dispute resolution mechanism where Africans play roles, where you have African arbitrators who are qualified, where you have Africans taking control of their destiny, so to speak. We would like to examine whether within the African continent, do we have anything, or do we have existing mechanisms or protocols that can also be utilized, or can also be looked at, or can also be helpful in looking at what the AfCFTA provisions are? And I think it would be nice if we start by calling Diane, who is an expert and who has looked into what obtains in the OHADA region. Diane, if you would like to please give us your view on the protocols currently in existence and applicable within the OHADA bloc. Thank you.
Thank you, Leonard Silk, and good morning, everyone. Might I begin by registering my thanks to the entire branch for this invitation to speak on this panel. So Tola has very the scene for us with regards to the negotiation and what the import and essence of the of AfCFTA is. At this point, Tola mentioned something very critical. He did say that AfCFTA essentially is modeled after the CTO, which is and AfCFTA's intent is to be a state-to-state dispute resolution mechanism. The first thing that comes to mind here is, considering that AfCFTA was modeled or negotiated for the purpose of ease of trade, ease of goods and services, movement of goods and services, and to break down the barriers of trade within the African continent. At what point are we going to answer the question of who actually does carry out this trade? And he mentioned that private actors have not yet been included in this. At some point during this discussion, I will delve into that. But I think that, AfCFTA really is strictly state to state, but the players and the actors within AfCFTA quite essentially would be private actors. And in looking at, OHADA and doing a comparison, I'll just give a background to the fact that OHADA actually is, an international organization set up by West and, some Central African countries. Its main goal really is to, the number of the member states as of now is 17 member states, right? It's really for the promotion of regional economic development within these member states and the harmonization of their business laws. So OHADA has the dispute resolution, part of it. It also has the treaty was signed and came into effect. But the thing about OHADA is, and I am very mindful of the time frame within which I'll be speaking, dispute resolution within the OHADA region has been simplified so much that it is easy to, rely on OHADA. Why do I say this? You would recall that Tola mentioned that we have 4 parts of dispute resolution under the AfCFTA dispute resolution protocol. The question again is, which of these should I explore? And he mentioned clearly that there is the fork in the road, and the fork in the road is really so as to, put a stop to forum shopping, if you will, because if you explored one, you wouldn't be given the opportunity to explore the other. But OHADA is clear as to the fact that once you go in for dispute resolution, arbitration, for instance, if you chose arbitration between the time when the panel, the dispute resolution panel is set up and the publication of that award, you have a total period of 6 months. You know, this in itself creates a full level of confidence, if you asked me, because we do know that dispute resolution would essentially be business to business. If it is business to business, then at what point would I sit and want time to elapse? Because we do say that the time value of money really cannot be underestimated, isn't it? So for a businessman, how is it that he wants to keep at arbitration, dispute settlement for longer than he can quantify? I am mindful of the fact that there are timelines within the protocol that within AfCFTA that ensures that certain stages are met within certain time periods, yes. But like we all know, when it comes to arbitration, for instance, we would have those allowances for extension of time. Something else under OHADA is the fact that it does have a court. This is critical because within the AU system, within Africa, we all have our various, jurisdictions and courts and everything. The question we would have to answer is this. At the time when you do procure an AfCFTA award, how do you enforce? Because if there isn't a smooth enforcement mechanism, then you're almost back to square one, especially knowing that there are more pro-arbitration jurisdictions within Africa, or there are differences in pro-arbitration jurisdictions within Africa. So the court for OHADA, all it requires is this. All you need to do is have the award exchequered. So you ensure that it is recognized by the body that needs to recognize it. As soon as that recognition is there, then it can be enforced anywhere as if it were a Supreme Court decision or the highest court decision of that particular enforcing state, right? So, and the time frame for this is also very short. The decision of the application to exchequer, right, is obtained before the competent court in any relevant jurisdiction within 15 days. It is deemed required, even if the court does not respond to you. So if court for some reason, maybe procedural, takes its time to get back to you, it is deemed that the exchequer has been consented to by the court. So that makes the OHADA process seamless and straightforward. It gives some level of we turn engenders custom to be set. The only court that can set aside, like the CCJA, which is that highest court. And you laid out reasons that it can be set aside for. The flexibility of the OHADA arbitration process, results from the fact also that waiver clauses to the result may be provided by the parties, provided that they are not in conflict with international public policy. It's very clear at this point, that unless, of course, the standard of international public policy, annulments are made about private parties. You see, where we are looking to engender confidence within AfCFTA, and I say this with every, every sense of respect for the work that Tola and every member of the negotiation team has carried out, in getting us to where we are. We also need to look at the fact that private commercial disputes are even more in nature. If they are more in nature, then how is it possible that we are not recognizing the fact that they will be settled? This is where confidence in the system must be built by including certain levels of private dispute resolution settlement mechanisms, right? That's first and foremost. I understand totally that the protocol for the settlement of disputes under AfCFTA, it really is was negotiated for things like, removal of tariffs, for instance. And this is public policy. It's for the states, but who are the players within the states? I will rest here and come back at some point, to talk about certain recommendations that where AfCFTA can borrow. Thank you for listening.
Diane, thank you very much for that. Your nice presentation. We have seen that now, even in Africa, within the OHADA region, the OHADA protocols indeed not only provide for easier enforcement of arbitral awards, but you find that the OHADA provisions are also very flexible. Before we wrap up on what we have in Africa, I'd like to very quickly bring to discussion Professor Abo Madaki, who is not just only practicing here in Nigeria. His interests go far beyond Nigeria up to East Africa. Professor Madaki would then go with us through what you obtain in the Comesa region. Professor Madaki, if you are please ready, we are waiting for your presentation. Prof, your mic is muted. Prof, your mic is muted.
Are you hearing me?
We're hearing you now. Please go on.
Okay, thank you very much for this very unique opportunity to contribute to this conversation on breaking down trade barriers in Africa and then looking at the issues of dispute that may arise in the carrying of trades between individuals and states. The coming into force of the African Continental Free Trade Agreement is indeed a very, very welcome development, because when we realize that Africa, with a combined population of about 1.2 billion people and a combined GDP of over 3.4 trillion, and yet the intra-trade relationship is 16% as compared to other regions of the world. Indeed, it is very worrisome. I do hope that this agreement will address it, because it has the potential and capacity for generating growth and job creation for the teeming youths and people of Africa. The objective of the agreement are very well captured in Article 3, and it is not necessary at this stage to dwell on it, but it seeks out to create a single market for goods and services, liberalize trade, contribute to the movement of capital and natural persons, lay foundation for establishment of continental customs, and all whatnot. And it is also expected that if this agreement is ratified by all the states in Africa or state parties, it's going to ensure new markets for African goods, generate economic growth in Africa. It will also attract direct foreign investment. Conflicts are bound to exist, and that is why over the course of history, mechanisms for resolutions of conflicts have evolved incrementally. So this trade agreement is no different because even Article 19 and 20 of it anticipates the possibilities or probabilities of conflicts and therefore have put in place provisions for conflict mitigations and conflict resolutions. That is why Article 19 in particular actually provides that in the event of any conflict and inconsistency in the implementation of this agreement, of course, that this agreement will prevail. But more specifically is Article 20 of the agreement, which actually provides that a dispute settlement mechanism is hereby established and shall apply to the settlement of dispute arising between states and parties, and that the dispute settlement mechanism shall be administered in accordance with the protocol on rules and procedures on the settlement of dispute, which means this agreement, like any other international treaties, expects the establishment of the passing of a protocol that will give effect to Article 20 of the agreement. And one of the objectives in the AfCFTA agreement is to establish a mechanism for the settlement of dispute concerning the rights and obligation. And then the DS protocol was actually also adopted in Kigali in 2018. And it proclaimed dispute settlement to be a central element in providing security and predictability to the regional trading system. And as such, a detailed institutional arrangement for the settlement of AfCFTA-related dispute is foreseen. Now, in order to save time, because I'm going to make available the full text of my paper, I want us to look at development of investment arbitration very briefly. The development of investment arbitration has become commonplace now. While investment treaties provide the framework of investment arbitration, the treaties need to be interpreted and applied. But there may be situations faced by an arbitral tribunal that neither the investment treaty concern nor the applicable law and arbitration rules addresses. In such cases, there's a general understanding that arbitral tribunals have inherent powers or the discretion to fill the jurisdictional lacuna to enable them exercise their power in controlling the arbitration process. Now, in East Africa, we have the common market for Eastern and Southern Africa, which is probably known as COMESA. Under the COMESA Treaty, the Commercial Court of Justice is established, and it is one of the 8 organs of COMESA. And its primary function is to uphold the rule of law in the operation of the treaty establishing COMESA. Its general jurisdiction is to adjudicate upon all matters referred to it under the COMESA Treaty. The court sits as a court of first instance with 7 judges. And then, of course, like most international courts, there's also the appellate division of the Commercial Court of Justice with 5 judges. The creation of this court stems from the realization that a stable and effective integration process needs a sound judicial framework. There are several provisions in the COMESA Treaty which make reference to the jurisdiction of the court. And perhaps the most important of this is Article 26 of the treaty, which provides as follows. Any person who is resident in the member state may refer for determination by the court the legality of any act, regulation, directive, or decision of the council or member states on the ground that such act, directive, decision, or regulation is unlawful and an infringement of the provision of the treaty. Of course, provided that where the matter for determination relates to any act, directive, or decision by member states, such person shall not refer that matter for determination under the article unless he has first suggested local remedies. Under international law, the referral of matters first, or the emphasis on the exhaustion of local remedies, is to ensure that the state involved have its own local mechanisms and familiar with the system and the law, and except you exhaust such local remedies, you don't immediately go to the Commercial Court of Justice. Again, according to this article, the court has power to hear a reference from a person, whether the person is legal or natural, who is resident in a member state, concerning the legality of any act, regulation, directive, or decision of the Council or of a member state on the ground that such as regulation, directive, decision is unlawful or constitute an infringement on the treaty. However, access to the court by individual and legal person is not without restriction, as is clear from the proviso to Article 26, which, of course, like I mentioned earlier, emphasizes on the exhaustion of local remedies before a party comes to the court. And of course, this principle is based on customary international law, and its rationale is that domestic courts and tribunals understand better the context of disputes occurring in their jurisdiction. It also has to do with the issue of sovereignty in traditional international law, which focus on relationship between states rather than an individual, and require the states against which allegation is leveled to be given the opportunity to put out what is complained or before the international forum can be seized of the matter. Of course, we know that traditional international law, in the beginning, only states, were subject of international law as individuals and not parties, but that has changed incrementally. Article 28 of the treaty, of the Commercial Treaty, has accorded the court specific jurisdiction to hear and determine matters as said. But it's also made provision for one, matters arising from an arbitration clause contained in a contract which confers such jurisdiction to which the common market or any of these institutions is a party to. So matters arising from an arbitration clause that is contained in a contract, the court has jurisdiction to hear it. Also, matters arising from dispute between member states, the court can hear it. It is important to mention that Article 28 has inherent limitation on the arbitral jurisdiction, in that only transaction involving COMESA or its institution and third parties and dispute between member states in which the arbitration clause or special agreement gives jurisdiction to the court can be entertained. In the absence of such provisions in the contract, then such arbitration matter cannot be entertained. Therefore, commercial dispute between private parties cannot be brought to the court for arbitration. Now let's look at the COMESA and then her experience with investment arbitration. Equally, the experience of investment arbitration by COMESA has soured the possessions of bilateral investment treaties. As at the end of 2014, about 61% of COMESA members had been involved in a total of 60 investment state arbitrations. And this was the involvement of this part of African states in this 60 arbitration. Regrettably, and I need to emphasize, regrettably, African arbitrators involved in these matters are only 15, which means a lot of the arbitrators that are involved in this investment state arbitration and proceedings are foreign arbitrators. And this is more like capital flight. This is more like an exportation of our dispute to foreign countries. Of course, by the end of 2014, COMESA members have concluded more than 15% of the total number of the bilateral investment trades, and then the dispute arising from them. The rise in investor state arbitration claim in COMESA is alarming. It raises concern not only about the investment climate in these states and the ability to comply with bilateral investment trade obligations, but given their development status, it also raises concern about the detrimental impact on their economies as a result of the amount of money spent on defending claims and paying damages to successful investment claimants. The underlying causes of the rise in investment arbitration claim in the commercial state include: 1, violent change in government; 2, legal and political instability in the aftermath of anti-government protests, like we had the SARS protests in Nigeria recently; conflict situation due to civil strife, which abounds all over Africa; then, of course, corruption; and then a change in government policy or law; and then insufficiently developed tax regime. The most common cause of investment dispute was a change of policy or a change of law. Such changes raises the issue of regulatory space required by developing states to be able to adopt new laws and policies designed to improve their economies and the lives of their citizens without the fear of being challenged by foreign investors. Like I said, the complete or full text of my paper is available for me to make is available for me to make available to the Secretariat. But for this treaty, the African Continental Trade Agreement, to achieve its objective as outlined under Article 3, it is very important that the protocol and procedure put in place for the resolution of disputes must be streamlined and simplified in such a way that, one, it will engender the trust of investors and the inter-African trade. Thank you very much.
Prof, thank you very much for a very erudite presentation which you have made. You can see that we have it also here in Africa. We have heard about OHADA, we've heard about the COMESA. I'm going to now ask a very distinguished senior advocate of Nigeria, former minister of the Federation, Professor Adetukumbo Akayode, to take us through what he will look at as the 4 set of rules that can be helpful under the AfCFTA. Prince Kayode, if you are please ready, we are happy to take the presentation. Thank you very much.
Thank you very much. I'm really pleased to be part of this program, and I want to thank the organizers for giving the opportunity. My colleagues who have spoken earlier have broken down the key background, the various institutions and the rules and the opportunities and the challenges. What I want to make clear is, from my understanding, is that arbitration or dispute resolution in interventions in commercial and trade disputes is basic under any circumstance. So commercial disputes will always arise from the operationalization of the AfCFTA. And this dispute will mostly be between private entities, business companies, whether multinational, private, and individuals who are in business, especially in transboundary trade and businesses across the continent. And of course, there'll be dispute between the states, but between state parties, but it will be less. Now, these disputes cannot be allowed to be, ought not to be allowed to be adjudicated upon by conventional or municipal courts, who by their nature are generally, and we know it, antithetical to trade in terms of speed, coverage, affordability, technicality, and so on. In any case, there's also the issue of trust. If I have a dispute between a company in Benin Republic, hardly will the Benin company want Nigerian courts to take jurisdiction, neither will I concede easily for Benin courts to take jurisdiction, unless, of course, we have otherwise agreed. So my suggestion is that under the AfCFTA regime, dispute resolution infrastructure should be all-encompassing for all commercial disputes between state parties, companies, individuals, and even non-state parties, who are by agreement adopted the AfCFTA dispute resolution body as their option for dispute resolution. Related to this is the fact that there are many rules on ADR on the continent of Africa, especially in terms of arbitration, mediation, and so on. Having so many rules for commercial dispute resolution is anti-trade and commerce, and we continue to hinder economic development and progress in practical terms. There is need, therefore, for relative uniformity of rules for commercial dispute resolution in Africa. This is where the AfCFTA dispute resolution rules must take center stage and precedence. AfCFTA should be the clearinghouse for all commercial trade disputes that may emanate from implementation of the agreement and international commercial transactions by state parties, companies, and individuals. This, I strongly believe, will enable uniformity to the rules of dispute resolution, integrity to the system, and act as a kind of monitoring for the relevant commercial disputes, and even help the reduction of commercial disputes going forward. So I want to say that dispute resolution within the framework of the AfCFTA must cover state and private commercial disputes within the area of jurisdiction, within the area in terms of jurisdiction and scope. The OPS, organized private sector, should be the driver of the AfCFTA business, trade, and commerce in Africa, and as such must be projected by granting them the access to the AfCFTA dispute resolution architecture. There's urgent need for uniformity of rules in Africa, as I've said, and this is a great opportunity for the continental free trade framework to provide leadership and direction. And this can be done seamlessly by making the rules of the AfCFTA the default rules for dispute resolution in commercial agreements on the continent. Party to any commercial agreement or transactions or parties in a dispute are should automatically be bound by the rules of AfCFTA, except where they have agreed to be bound by other rules. And this will provide some level of certainty and the assurance that whenever you have a transaction across the border, you know exactly which rules will apply unless you are able to agree to other rules. Secondly, the venue of dispute resolution will also be unless otherwise agreed. For instance, maybe the country of origin of the arbitrator, where there are more than one arbitrator, or where there are more than one arbitrator to the arbitration or to the ADR, whichever form of ADR system adopted. And again, because you know that if again there's a dispute between a Nigerian company and a Ghanaian company, hardly will either one of them agree that it should be done either in Nigeria and Ghana. So if you have a third arbitrator, that means that automatically, unless otherwise agreed, that the venue of the arbitration will be the country of the presiding arbitrator. All this, I believe, will ensure direction, uniformity, and integrity to the international to the continental dispute resolution in Africa. It will also strengthen the gains we hope to make from the CFTA and provide it with a yardstick and review mechanism for making new rules and policies for better trade and commerce in Africa. This is my intervention, and it's principally that we should, the AfCFTA's architecture for dispute resolution should be all-encompassing, and unless parties agree otherwise, this should be the default rules for implementation of disputes. Thank you very much.
Prince, thank you very much for your very kind presentation. I think we have had it all. From the panelists, it's obvious that Africa is now ready to deal with its own problems. The fear which was expressed in the morning, earlier in the day by Mr. Lumumba, that the international legal infrastructure is a neo-colonial mechanism, and therefore that African dispute resolution mechanism ought to be put in place, may not really take us to any place to fear about. We have now seen what happens in the Ohada region. We have seen what happens in the Comesa region. And in discussing his own presentation, Prince Kayode has introduced a very dynamic angle that the AfCFTA disputes settlement mechanisms ought to be the default mechanism for all over Africa, so that if you have, if you are in Nigeria and you have a problem which is not really provided for, the AfCFTA provision should be able to guide you in that aspect. That he thinks would promote certainty in managing disputes within Africa and by Africa. Very interestingly, Professor Madaki introduced the issue that within the Comesa region, they have had quite a lot of investment treaty disputes, but he was worried that in dealing with this number of these investment treaty disputes, that the Africans who have been parties or who have been players in the arbitrations in those areas were quite less, that you had more of them as foreigners. And then what I'm going to ask the panelists to look at, how do we ensure that in managing disputes under the AfCFTA, which, as you have heard, is tailored mainly along WTO provisions, how do we ensure that African arbitrators who are obviously qualified, and we have quite many of them here in Africa, African arbitrators who are qualified indeed play the actual or play active role in managing dispute settlement in Africa, presently which is between state parties. And if eventually it expands to dispute between private individuals. How do we ensure that African arbitrators are really involved in this? I would firstly ask Onayemi, who was part of these negotiations, to let us know whether there's any arrangement, any provision in the AfCFTA to ensure that African arbitrators indeed play active role in this settlement in Africa.
Thank you for that question. So I think it's important to make recourse to Article 10.3. First thing to say is to say that Professor Madaki mentioned the fact about a protocol for the actualization of the AfCFTA. That has been set out already. There's actually something called the Protocol on Rules and Procedures of the Settlement of Dispute of the AfCFTA. And Article 10.3 of it says that individuals listed on the roster shall have expertise or experience in international law, other matters covered by the agreement as it relates to this resolution of disputes, shall be chosen strictly on the basis of objectivity, reliability, and sound judgment, being impartial, and it goes on and goes on. But the point is that basically it depends entirely on state parties. Each state party is under the AfCFTA designated to nominate 2 individuals for inclusion in a general indicative list. So the truth of the matter is that every country, Nigeria included, has to send 2 persons to the list. What has happened with most tribunals in the past, why you see that there are no African arbitrators, is because the countries will generally send foreigners. So the pressure should be at the national level to say states already have technical people that are technical prowess in Africa, and they should be consulted. That's one. So the indicative list is actually entirely nominated by state parties. So states decide who will be there. That's one. And that's the first thing to say. And let me also say one thing to clearly distinguish. On the 4 parts of negotiation, this is the arbitral panel one. On arbitration, more specifically, state parties also have the right to pick who they want to be the arbitrators, right? So when you're saying you want to have 3 arbitrators, state parties can decide which of the arbitrators. And what we've seen happen, when I was last in Addis and on that meeting I went to in Tanzania, one of the things we had to discuss was arbitration centers in Africa making a strong case to say they wanted to be arbitration centers for the AfCFTA dispute, where if member states choose to go to arbitration as against arbitral panels, because arbitral panels are controlled by the Secretariat and the member states, but when you go to arbitration, you are basically going to that. And that also is a choice that member states. So the truth is, it's entirely left to the sovereignty of member states. The state parties, the members to put on indicative list are selected by state parties. If state parties decide they want to go to arbitration, it's made by state parties. The last thing I was going to say is that it's important to also say that the AfCFTA is supposed to set out the rules for trade within the AfCFTA region. It does not in any way limit private parties to use any other systems they want to use for arbitration. So for instance, we currently have the WTO as a mechanism for trade within the world today for deciding that. But the truth is, regardless of that, we have so many arbitration centers all over the world that can do the work of arbitration. So the truth is that also exists, that member states can decide, and private citizens can decide to go to any arbitration centers to resolve the dispute, because most times what will happen is, as lawyers, as you're designing your contract, you will designate there where you want your arbitration to happen or what you want your dispute settlement mechanism to be. And so member states still have, private parties still have that entire independence to go to any of that. So the truth is, there's a lot of room for African arbitrators to play. The hope is that, one, member states will designate African members as their members that will be part of the indicative list for arbitral panels. 2, that if member states want to go to arbitration, they would also pick African arbitrators. And 3, the private sector parties who will choose how they want to do the arbitration will by themselves choose to go to African arbitrators. So the truth is, that already exists. And the truth is, the technical expertise already exists on the continent, and you're already seeing a lot of those people already participating. So I know of a number of arbitration centers that have reached out, that are having conversations about becoming centers. I know about a number of arbitrators that are also making overtures. So I think there already exists a behemoth of African arbitrators that are already making a case for that. And I suspect that you might even have a system where it would almost entirely be run by African arbitrators. Because don't forget, it's entirely designed by Africans. The negotiations are done entirely by Africans. What you have so far is done entirely by Africans. Thank you.
Thank you very much. Before we go further, I probably think that it would be necessary for us to have Professor Madaki to further share with us. Prof, in view of your experience in the COMESA, and it was worrisome that you mentioned that for the investors and arbitration they've had, that many of the arbitrators were foreigners. Do you have any experience why the African arbitrators were not preferred in those aspects of matter, those disputes? Because what we are trying to do here is to see that we do not create a big economy, and then there will be now another capital flight, and they will now have to worry about where is this our capital going to. Professor Madaki, so do you have any experience why the African arbitrators were less patronizing, if I use that word, in resolving those disputes in those areas? Professor Madaki.
I can try out.
Is Professor Madaki still here with us?
I think he's dropped off the call. I don't think he's on the call.
Oh, I see. Well, before you,
may I make
before,
my hand
before,
is, I have, Mr. Chairman, my hand is up.
Let me come to Prince. Prince, what I was going to ask you really to deal with us is that I know that apart from your role in this year, you also had a very, very important role in trade and commerce in Africa as the current president of the Chamber of Commerce here in Abuja. Are there plans to have, now we hear that this AfCFTA is mainly dealing with state-state disputes. How are we going to ensure that disputes between individuals who are not states, but private individuals who are trading on a large scale within the continent have some measure of remedy in the event that they have disputes that can be governed by the AfCFTA protocols? Are we making efforts to see that the relevant organs review or now expand the provisions to accommodate private individuals and their disputes within the context?
Thank you very much. I want to first of all take the question you were trying to push to Professor Agbo Madaki.
Okay, very good.
First of all, you see, the tendency for us, we as the owners of these disputes, we love this idea of exporting our disputes. You see, we must domesticate our dispute resolution mechanism. This era of people, okay, and COVID has taught us a lesson. The era of people taking the dispute to SCIA, to ICC, to even now to Singapore and to Malaysia, the AfCFTA must put an end to this. We must domesticate our disputes. We must do our disputes right here in Africa, okay? And so, and I think that the uniform rules made under the AfCFTA protocol can implement this. And this will also go to answer the next question you posed about what are we doing, what can be done. I can tell you now, right now, that the African Union, working with the private sector in Africa, is operationalizing the African Business Council. The interim president is Dr. Asfoa from Egypt, and the vice president, one of the vice presidents is Engineer Mansour from Nigeria, and I'm involved in the council. I'm also the vice president of Pan-African Chamber of Commerce, and what we're looking at is to support the AfCFTA to create that platform, those rules, of course, working with every other person, especially the professionals like myself, like yourself. We're all fellows and chartered arbitrators. So to create that platform, one, to ensure that we domesticate our disputes. Any dispute arising under the AfCFTA protocols and framework must be resolved in Africa. And secondly, we must also have these rules that we know is applicable unless otherwise agreed, either by individuals or by state. And this can be done comfortably, because unless we do that, we know the score. Why should I have to go to London to, resolve a dispute, between me, my company, and a Ghanaian company or a Chadian company? Why can't we do it in Burkina Faso or do it in any other nearby country? Or even in the same country, bringing a third party who is also an African. This is what we must do. And we need to clear our brain from this colonial mentality of thinking that unless something is done in Paris or is done in London or elsewhere, it should not be genuine, authentic. You see, so it's a colonial mentality thing, and the AfCFTA can help us to clear the cobwebs in the corner of our brains about this. We must domesticate our arbitration right here, right here. There are so many centers now We have Kigali, we have Lagos, we have Kigali, we have Cairo, we have Casablanca, we have domestic centers like the Gazama Center, the Bayojo Center. We have the one Abuja Chamber of Commerce. So why can't Ghanaian Chamber of Commerce, of course, for instance, we have an MOU with the Ghanaian Chamber of Commerce. Then we can develop it further so that any dispute arising from members of that chamber can bring somebody from Nigeria as presiding arbitrator, and I will take it further like that. So this is the whole essence of having those default rules, which will cover the field. We must domesticate our arbitration, and it can be done under the protocol and the framework of the AfCFTA. Thank you.
Thank you very much, Prince. Prince, I will come back to you again, but let me quickly ask Diane, what do you think is possible to be done to harmonize the various centers which Prince just mentioned in Africa or within the region? And I have in mind particularly, how do you think we can have a synergy between what you have in the OHADA and what you have in ECOWAS, what you have in COMESA, so that we can have some working arrangement between these various regions and the dispute centers that I know that exist in these areas, so that we can actually have our disputes, like Prince just mentioned, domesticated in Africa.
Just tell him, I'll finish this.
Diane, did you get my intervention?
Yes, I did.
Sorry,
Okay. So are you able to give us a view on that?
Yes, I will take it from the end and walk back to your question. So ultimately, what is our goal in Africa? Our goal really, when it comes to arbitration, is to ensure that Africa is an arbitration-friendly seat, isn't it? So if we looked at this and told ourselves that this is the goal we would like to achieve, how do we achieve this? At this point, I will go back to what Onayemi mentioned about the fact that each member state has the opportunity to nominate two members on that panel. And I say that this is not enough. The truth is, like he rightly alluded to, there is so much talent, there is so much experience when it comes to arbitration and dispute settlement on the continent. So if you said, for instance, that Nigeria would nominate two, who are these two? And what happens to the others? That brings me now back to the dispute resolution centers. If we thought to ourselves to say, we could harmonize to have regional arbitration centers, right? So for the purpose of AfCFTA, we know that for each region of the continent, there are these recognized dispute resolution centers that, all such disputants would administer. In administering, you know that this raises the level of expertise in these centers. This also gives some sort of transparency and harmonization and a predictability. Because if I took my dispute to this particular center, I know that I'm bound by the same set of rules as if the next dispute as the next dispute coming after me. So it gives me some confidence that I am sure the same treatment to, because the rules are the same, the administration is the same. That in turn fosters on these dispute resolution centers the responsibility and the obligation to bring themselves up to par with the ICCs and the LCIAs and all of these other, administering institutions. They would be forced to train. At the time that they are training the dispute resolvers, all of the actors within, the dispute resolution space, we're getting more and more education, more training, more experience, and that brings more confidence to the continent. The truth that we need to tell ourselves is first and foremost, even us within the continent are not as confident as we should be in our own systems. That's the only reason that, or one of the reasons rather, that we're taking or exporting these disputes outside. I recognize the fact that Prince mentioned that, there is the colonial mentality. Yes, as soon as we eradicated that, then we come to the next question of confidence, transparency, and trust in the system. And Prof, mentioned corruption. So if we harmonize this regional center, this dispute resolution centers, the administering centers into regional centers, I think it would engender more confidence in the continent and ultimately make us an arbitration-friendly continent. Thank you.
Thank you. We have quite a number of questions that have been put forward on the chat room. Before I come to those questions, let me just quickly, now that we have got Professor Madaki back. Professor Madaki, if you put back your mic, we had posed a question which Prince did hold brief for you and answered. But we would like still have to have your intervention if it's possible. We are wondering whether you have any particular experience or knowledge or information why, for those many disputes that came up in those trade investment disputes, the African countries who were involved in those disputes rather preferred to engage foreign arbitrators instead of the local African arbitrators who may have resolved the matter. Was it that there were no African arbitrators that were interested, or there were no Africans that were qualified to deal with those disputes in those regions? Professor Madaki, are you still with us here? Professor Madaki. All right, we'll come back to Professor Madaki later. Now, we have got quite a number of questions on the chat room.
Can I just respond to something Ms. Diane said?
Yes, you can, please.
I would like to say a few words too.
All right. I think it's important to give proper context, right, without we engage with the issues. There's a distinction between arbitration as a way to resolve disputes under the AfCFTA and more generally, the arbitral panels. What I said about states sending 2 member parties was as regards the arbitral panels. If you take 2 arbitral panel members from 54 member states, that's 108. That is a 108 member arbitral panel that will deal with disputes. And that's how it happens all over the world. So it's a distinction from the arbitration where you can choose to go to anybody you want to go to and can apply to any system you want to go to. But the idea of 2 member states sending 2 persons was for the arbitral panel. And I think it's important to say that so that we don't discredit the system and make it seem like it's not reaching enough for arbitrators. Arbitrators have an entire stream of their own, which is the 4th part, which is that member states can decide to go say, I'm going to arbitration anywhere and do that. But within the dispute settlement system, the arbitral panel parts, there is a 108 member strong system where each member sends 2 persons. So that's what I just want to make that quick distinction. To say nothing affects the arbitration, everyone can go to arbitration as many times as they want. But when you talk of the 2 members nominated by state parties, it is for the arbitral panel, which is already set up between the AfCFTA. The last thing I would say more generally is that I think there's a big issue generally with dispute settlement on the continent as regards speed. And I think that's the real issue when private sector parties, because truth is, private sector parties will always choose what's the most beneficial for them in the end. State parties, you can even constrict to say, go to these certain centers. But when it comes to arbitration, and I've had to advise a lot of clients on international deals, a lot of them will tell you, I prefer to go to this jurisdiction. And the reason is still a number of times speed and the depth of competence that exists. And so the truth is, as we get more competence here, and as we are a lot more clear about speed, what you would see is that naturally people will come and set up more. You're seeing a lot more arbitration happen in Mauritius over the last few months. We're seeing a lot more happen in those kind of jurisdictions. So that would happen. But I just want to make that clear distinction between the arbitral panel part, which is 108 members, and general arbitration where you can go to anybody you want to go to as a member state. Thank you.
Thank you, Tola. We'll come to you, but I think what is important that we need to underscore is that in even choosing the people that represent you in the arbitration, what I think is a consensus is that there is now need to be more emphasis on African arbitrators who are experienced, who are qualified. One Prince was talking about colonial mentality, If you have the panel that you have made up of Africans, and parties, state parties choose to go to France or go to London or go to America and choose to bring Mr. White or Mr. Black, as against bringing Mr. Onayemi to be the arbitrator or to be their counsel in the matter. This is what we are trying to deal with. And I think Prince was right when he did highlight the problem of colonial mentality, which is our bane. Now, Prince, we're going to say something before, otherwise I was going to bring you to a question put on by one of the attendees. So, Prince, can I bring you to that question?
Yes, please.
Now, somebody has asked a question here, and it's very interesting to look at that question. He says, do you not think it's an obvious omission by the draft of this noble agreement in failing to recognize the roles played by private sector in the economy of their nations, particularly in international commerce in African states? And he says the lives of Dangote and the communication moguls. And please, because of their unique position in private sector commerce in Nigeria and all the roles we are playing, do you think that this is an obvious omission in the AfCFTA? And if it's an omission, how quickly can we have this omission corrected?
Okay, thank you very much, Chair. You know, the AfCFTA
I'm just your servant. I'm just the moderator.
Oh, okay, all right, moderator. Thank you. You see, the AfCFTA is actually a public service thing. It's driven by government officials. Okay, that was an error, but no problem, because as I said, the same African Union that drove the AfCFTA is pushing now the African Business Council. They've even made it, giving it a diplomatic status, an observer status within the African Union Commission. So it is fine. Dangote, the Afro champions, they are the Afro champions that are one of the key core members of the ABC, the African Business Council. So they're being integrated gradually. Don't forget that even in Nigeria, it's a big problem for private sector to engage with government, because government officials believe that they own it. I'm the Minister of Trade. So who are you? Forgetting that ministers don't trade, neither the government trade. It's individuals that trade, it's the SMEs that trade. But gradually we're breaking this down and getting people to understand, whether at continental level or national level, that it is a collaborative thing. Private sector, government, public sector must work with the private sector. So it's gradual and it will work. And another thing that we must ensure that the private sector drive the architecture and the structure, as well as the operations of the dispute resolution mechanism that we put in place. And finally, I also want to respond to what my colleague Carol talked about harmonizing the various groups or other platforms and so on. I think all that can be resolved. If you want to have that rules, agree to it, or in default, you will have the AfCFTA rules. And I think that solves the problem. But the critical thing is this: any dispute, and it should be embedded in the architecture, that any dispute between African companies or companies registered in Africa or African states or a mixture of them must, unless otherwise agreed, take place in Africa. And the emphasis should be that the dispute resolution must be in Africa. If you like, you can bring somebody from Namibia to go and do your dispute, that's fine. And so gradually, you see, the AfCFTA is to break down the sub-regional grouping, ease it off so that we can really begin to build a united continent, a continent whereby all of us can move freely with a passport or an ID card. Why should I need a passport to go to Benin Republic? Thank God we don't even need a visa to do that. But technically speaking, you need a visa to go to Cameroon from Nigeria. Again, thank God that between our two countries, we know that we are just one, so you can do that. But why do I need a visa to go to Central African Republic when half of the people there are Fulani and Hausa, and many of them claim Nigerian origin? Why do I have to go to Sudan with the passport? Why do I have to? So the bottom line is this: the AfCFTA are given an opportunity to unite Africa, not only in terms of political unity going forward, but also to unite our business, to strengthen our business, to enable us to do more business, create more opportunity. Look, The bulk of the food in the bulk of West Africa, Liberia, Sierra Leone, Gambia is imported. They import fish, they import rice, they import chicken. So why can't I load my truck from here, or even go and buy chicken from my friend's poultry in Benin and take it to Gambia? Why shouldn't I be able to flow freely? Why should Nigerian government lock the border between Nigeria and Benin Republic? Yes, there are bad things going on. People are smuggling. So what? Let the custom deal with it. Strengthen the security system, but you cannot shut down the border. Okay, now they're not. Look at today's newspapers. They shut down the border, but they said there are about 206 crossings, and we know they exist. So who is fooling who? So the same thing, people taking the arbitrations abroad or bringing foreigners to come and arbitrate the arbitration abroad. So we can do it. This is a platform, this is an opportunity for us. But for Nigeria, it's a bigger opportunity than for any country, because we are the biggest traders in Africa, and you know what I'm talking about. We are the biggest traders in Africa. We're the business people, and we're involved in everything that's going on in Africa. Most of them good, a bit of them bad. But then we are not saints, okay? Nobody is a saint. But the important thing is that we must push, use our weight in Nigeria, Nigerian Charter Institute, use your weight to push that agenda through the African Arbitration Association, through all the other platforms that exist in the continent, to ensure that we have this, and also providing leadership. Because of the delay in signing the AfCFTA, we lost the leadership.
Prof, before you, Prince, before you sign out, are you still with me, Prince? Hello, Prince. Prince.
From us, we must continue to provide Africa, okay? But that is my response to the question you have asked.
Prince, before you sign out, I was going to just to take you one minute again. Before you sign out, there's a question that was put here, which I think is central to what you are saying. And I'd like you to have your view on that. And the question is about whether there will be a unified arbitration law for Africa. In view of what you are saying about uniformity and default. So is there is there a chance that there will be a collaboration? Is there a chance there will be a collaboration, or there will be a unified arbitration law in Africa in resolving disputes?
Yes. Thank you very much. This is the target. Let me give you a typical example. About 2 years ago, the ICC rolled out the expedited rules, I think that's what they call it, on arbitration, just to see how they can expedite arbitration. And what did we do in the Abuja Chamber of Commerce? We adopted it, even added more clauses to make sure that it's even faster and cheaper. So we can look for best practice anyway, adopt it. The Singapore mediation rules, we adopt it. We can have a rule that an African rules and law on arbitration, which will simplify everything, streamline everything, providing certainty and assurance. So that's the ultimate objective. And I want the Charter Institute of Arbitration in Nigeria to provide leadership. You know, why is Mikel there? I mean, on Gazjeke and on Chibayojo, provide leadership. You're already doing it and you are making good money from it. So provide leadership, bring a model law, let's push it through. And it can work. And if Nigeria pushes it out, you will have a lot of support and regard, and also put us in a good position to play a critical role in the great game that will ensue because of that. You understand what I'm saying? And
yes.
Not only this, we also remember, sir, we also talk about sports. You understand what I mean? This is the platform for creating some of these opportunities, and we must not allow all our disputes in sports or other areas. Please go to Oxford or go spend so much money to go and learn about arbitration in Europe for us to now export our arbitration again. And some of our members are so happy. Oh, I was in London.
I know your passion for sports arbitration.
Do it here in Nigeria. Thank you.
Please, I can understand your passion for sports arbitration in Africa. I know that. But now that you mentioned sports, which are the specialized area, there's a question that is on the chat room, and I would like each panelist to just in 1 minute to give his view on that question. And let me put that question, which is for a specialized area that is developing. But I think those who practice that area of arbitration they find it quite very interesting. The question is relating to whether, I'm sorry, let me get that question again. 1 minute, I'll get that question again. Yes, he said, should the maritime industry set up arbitration guidelines and ad hoc committee to oversee inter-trade disputes, giving credence to the emergence of the AfCFTA? So what he's asking is there any chance that the maritime sector, which we all know is very specialized, can also benefit from the AfCFTA protocols? I would like to start with Mr. Tola Onayemi. If you have just a minute or so to give us your view on this, then we'll come back to Diane and we'll come back to Prince. But Diane, when you are giving your view, please just note that somebody would like you to throw a little bit more light on OHADA. Thank you very much. So Onayemi, please go.
So definitely, I think maritime. I think every industry on the continent will benefit strongly from AfCFTA, and the reason is very simple. You're talking of a market of 1.2 billion people and $3 trillion, right? And you're talking of an harmonization of markets. So basically what you're saying is you've got to get goods and services across. You're going to have to use the waterways, right? You're going to have to use, and so what in fact I think will start to happen is that you start to see a lot of harmonization of the rules along the same paths. Because what needs to happen now is that I now can use any of the borders to get to anywhere, right? As long as it's either I'm paying duties and I'm clearly designating the last market. And so what will basically start to happen is a case where it becomes a competition for who has the most competitive maritime industry and who has the best ports to get products in. And so I suspect that I foresee a case where there's going to be an improvement in maritimes, there's going to be standardization, there's going to be a lot more harmonization of standards, mostly because now everybody's trying to provide the similar rules so that players can access which of them and decide which of them provides them the most benefit. And I think that's basically what you're going to start to have, where, because you're going to try to get goods across, you're going to have to use the waters. If you're bringing goods from external components, from external third-party countries outside the AfCFTA, you're going to have to use the waters. And the truth also is that now I have a bigger case to make, because someone can say, you know what, get my product to the Togolese port, I'm going to get it to Nigeria regardless, because I just have to designate that it's coming to the Nigerian market and pay duties, final duties to the Nigerian market. So the truth is, and that's what you would see with not just maritime, but with things like digital services, e-commerce, air-freight travel. You're basically creating an incentive for 1.2 billion people to serve. And that basically changes the game quite a lot. So definitely, I think there'll be massive improvement in that.
Thank you very much. Diane, do you have anything to make by way of intervention in this respect?
Thank you, Leonard Silk. I quite agree with Tola, because as soon as we have those harmonized rules in whatever sector there is, maritime inclusive, then, there's a standard for performance, so it goes without saying that if you had the same set of rules, the same laws and regulations that each member state is working with, then it's a lot easier to implement. So for OHADA, for instance, that has, those uniform arbitration laws and the business part, a lot of business within the OHADA region has totally been simplified. It's like the walls have been broken down. So intertrade within OHADA is a lot easier. This is what will happen here. But I go back to enforcement, because within the African jurisdiction continent, there are several jurisdictions. Enforcement may pose a problem if we do not have also the uniform sets of rules that guide enforcement. So I return to saying that there is a strong recommendation that we have that singular court that gives some sort of credence for the enforcement of these awards, post-arbitration awards, because at the end of the day, you do have an award you want to enforce, right? So let's make enforcement a lot simpler. Thank you.
Please, I know you mentioned about sports arbitration, but the question that was put to us to deal with is whether maritime should also benefit from this after protocols.
Well, I think, maritime, sports, even oil and gas, telecoms, technology, they're all specialized parts of arbitration. Even now, people are now arbitrating mergers and acquisitions and other stuff. Look, the boundary is unlimited. In fact, there's no boundary. So far as arbitrable, all of this can be accommodated within the framework of the ADR system that we must put in place. Yes, why not? Maritime should. If it involves African companies or African countries, let's do it under the protocol, under the framework, and we can adopt best practice rules and now panel-beat that to suit our own purpose. We make sure that we reduce the time and we reduce the fees. Because one of the challenges I think we also have is the cost. But all of that, we can work it out. But yes, all the specialized areas, whether it's maritime, power, all these new areas that provides opportunity for us, it helps. Secondly, it also helps our professionals, but I do not think that ADR should be taken as only a lawyer's matter. It is not. It has never been. I want our professionals, maritime experts, maritime engineers and surveyors and maritime architects, everybody involved should be in this mainstream. The same thing with all the other professionals in every sector and every field. So we will have sectoral arbitration specializing in the different areas. It can all be accommodated within the framework.
Well, I just want to interrupt because I wish we have the whole day to discuss African issues and arbitration that pertains to Africa. But let me firstly sincerely thank all members of the panelists for your very kind presentations. You've done very good work to what has been given to you. Our time is up, and thank you very much for listening.
Thank you very much.
Thank you.
I'm sure that you will have your paper